Our next speaker is my partner, Kevin Clark from Lightfoot Franklin White in Birmingham. I'll say you're in for a treat. Kevin is one of the most gifted public speakers I've ever heard, and I know that from first experience hearing him give talks like this, but also trying cases with him in the courtroom. Hearing Kevin give a closing argument to a jury is a near religious experience, as you're about to find out. That's because he spends most of his Sundays in the pulpit preaching. So he knows how to talk to folks. Kevin's practice is varied. He spent a lot of time in toxic tort world, wrongful death cases, personal injury cases. He's recently been named as a rising star in the Alabama super lawyers. Kevin has spent a lot of time in the last couple of years in the DRI Toxic Tort Committee. I don't know if any of y'all have ever been to that. He's run that seminar and been the head of that committee for DRI the last 2 years. Kevin has also served as program chair for the DRI Diversity for Success seminar and has run that program, which gets to his topic that we're here about today. We all know that diversity is an important topic in our law firms and with our clients, but Kevin's going to give us some insight on why a diverse trial team can be a winning strategy at trial. Please welcome Kevin Clark.
It started out innocuous enough. Had my must-do list completed, went to the airport. Everything's fine, so I board the plane. And I recognize that while I'm flying first class, my partners and their lovely wives are not. And they're a little perturbed about that. And so that's the beginning of a sign this may not be a great, uneventful trip. As we continue down that way, we get to Atlanta and we board the flight to San Diego. And I come in and I see one of my partners, Stephen Rowe. I avert my eyes in shame, not wanting to make eye contact. And then I get to my seat and somebody's sitting in my seat. And so I do what everybody does. I pulled out my ticket, looked at it again, 7B, all right, 7B. And so I looked down and said, sir, is this 7B? He says, 6B, and looks, oh, I'm sorry about that. Could you sit ahead? No problem, I'll do that. And so as I turn away from him, I accidentally, with my bag, hit him in the head. And I say, I'm sorry, and I sit down. Then the airline attendant comes to him and says, well, you guys have a great show this Saturday, don't you? And then it begins to dawn on me that I have just practically told this man to get out of my seat, hit him in the head, and he is ESPN Game Day co-host Kurt Herbstreit. Not a great way to start that flight. But I will tell you, there is cosmic justice in the world. Because later in the flight, sitting ahead of me was his co-host, Des Howard, who proceeded to spill coffee all over my papers. And so what goes around comes around. But I will say this, I got his signature, and the only thing I could sign was my printout of my presentation, which brings me around to what I'm supposed to be talking about this morning, which is diversity in the courtroom. But before we do that, let me suggest this, that diversity is a very important thing. And it is something that we need to think about, and we need to strategize about when we're talking about how to defend our cases, getting them ready for trial and going to trial. And I would suggest to you that there are some who would take issue with whether that is even relevant, whether we should have these discussions. There are attorneys who think race it has nothing to do with anything, should not be a part of the strategy, should not be a part of the discussion. And if it is, I want to step back a little bit, if that argument is being made, to suggest or ask the question, does race matter in life? How many people, raise your hand, recognize that individual? Okay, we got pretty good representation. That is Warren Moon, and he's inducted into the National Pro Football Hall of Fame. Now, if you're a football fan, you've seen a lot of people induct into the National Pro Football Hall of Fame, a lot of quarterbacks. But I want to tell you that this induction was special for me. It was special because it's the first African-American quarterback to be inducted into the Hall of Fame. And if you know the backstory, that here is a great athlete coming out of the University of Washington, was a phenomenal athlete and quarterback, and yet because of the presumptions about African-American men and their inability to lead and their inability to master the intellectual aspects of quarterback, he had to go play in the CFL for several years before he was allowed to come back in the NFL and start there. Does race matter? Absolutely, it mattered in this case. Does race matter when it comes to the appointment of Justice Sotomayor? I'm sure many of you read and saw the jubilant reaction in the Latino community to the fact that this is the first Latina justice to sit on the U.S. Supreme Court. Does race matter? Certainly it does. Or remember Jeremy Lin. I remember reading in the New York Times all kinds of articles about what he meant to the Asian American community, but also in Asian communities across the world. Does race matter? It certainly does, or did, in that situation. And who can forget this? Perhaps one of the most racially divisive occurrences in our history. Yes, race does matter. So the question is this: if it matters in life, why not in the courtroom? That's my question. And if it does matter in the courtroom, don't we owe it to our clients to bring that issue to the table and have an intelligent discussion about that? Let's talk about a few things in the limited time left. Number one, the effective use of diversity requires the input of diverse attorneys from the outset of the case. You know, we talk about diversity in the courtroom, but this starts the minute the case comes in. And we have a frank assessment of the demographics of the jury. We have a frank assessment of the demographics of the judge. We think about that in terms of staffing on our trial team. We think about that in terms of the witnesses. Some of the talk that this morning is going to be focused on lawyers, but I would suggest to you, equally if not more important, are the racial dynamics of witnesses. We need to think through that and have candid discussions. I had a partner the other day give me a call and ask about a certain African-American judge and whether he should assign an African-American associate, and if so, who that should be. Those kind of discussions should be had. And there's not just an automatic rule to that. Now, having said that, I will say this. Many times people are fearful that if you put an African-American attorney in front of an African-American judge, that's going to be perceived as tokenism. Well, it can be. It depends upon how that attorney performs. I've talked to many, many black judges. They're all aware of the dynamic that their presence diversifies the lawyers who come before them. And they think that's a good thing as a general rule. There are exceptions, but as a general rule, that's a good thing. But don't you dare put a minority or an African-American attorney like myself and not give us the tools we need to succeed and not have us prepared. Now, that will backfire on you. But those are the kind of discussions we need to have. And those discussions need to be had with diverse voices at the table. We can't do this with a non-diverse audience. We can't have a bunch of white men talking about how the Latino community is going to respond to this and how the African-American community is going to respond. We need everybody at the table. Let me give you a vignette to illustrate that. We had a trial, it was a toxic tort trial that we were trying, and we were going to cross-examine one of the plaintiff's treating physicians. And he shared an ethnic background with one of the female lawyers on the trial team. And she came to us and she said, guys, I'm going to tell you something that you don't know. Now, put aside whether you agree with this or not, listen to her assessment. She says, in our culture, this man is going to have a very difficult time with a woman being in a position of authority and questioning him on the stand. And I think that's going to rattle him. I think that's going to bother him. And so based on that, we decided to have her cross-examine that witness. And I'm going to tell you, she was extremely effective. Now, she would have been effective anyway. And I can't tell you 100% that her analysis was right. But I can tell you this, having been in that courtroom and watched that, it was strange to me how he was so prickly over the most innocent and innocuous of questions. So maybe there is something to that. And you may say, oh, that's distasteful. I would never do that. I would never make that decision. That's fine, but here's the point. Her voice needs to be at the table. And that decision needs to be a decision deliberately, not born out of ignorance. And so we need to have diverse voices at the table. And let me suggest this. Have candid discussions with our clients. We have clients on this issue who have brought it to the table to us. Lee and I had a case where the client essentially had another jurisdiction. It was out of state. It wasn't in Alabama. And based on his understanding, it was predominantly African American. And so he wanted me to help try the case. Now, I'm going to leave that there and come back because there's an ironic twist to that at the end of the talk that I'll come to you. But the point is this. Clients want to know and want to hear about these things, and we can have intelligent adult conversations about that. Secondly, don't forget the advantages of diversity in fact investigation. Let me give you a vignette that may illustrate this. When I first came to Lightfoot, I was put on a case involving a chemical company, and they had allegedly polluted the neighborhood, a predominantly African-American neighborhood, with a certain chemical. And so they were having these community meetings, and we wanted to get inside those meetings and hear what was being said. Well, there was a problem. We didn't have anybody African-American until I came on board. And so they said to me, Kevin, we want you to go to these meetings, dress down. I had not been at any hearings. I had not taken any depositions. Nobody would know who I am. And so I went to several of these meetings, heard what was said, brought back a written report to the client, and so we kept our fingers on the pulse of the community that way. You say, well, couldn't a white attorney have done that? Absolutely they could have done that. But go back to the title, putting the odds in your favor. it's much less likely that I'm going to be outed as an African American in a room full of African Americans than my white counterparts. That's just facts. So think about this as well. This has come up several times. When you hire a private investigator, take a photograph of a house or something of that nature, and it's in a predominantly minority community, do you use a minority investigator? Why might you want to? Because if you're worried about being discreet and not being noticed, it's going to be less noticeable if there's somebody who has the same skin color as the rest of the people around them or shares the same ethnicity. Am I saying you always do that? No. Am I saying that a person that doesn't have that minority affiliation can't be effective? No. But I go back to putting the odds in your favor. And then a minority attorney may communicate more effectively with minority counsel. And I want to emphasize may. I'm not saying this. All black lawyers know each other, and we're all great friends. I'm not saying that just because I'm black and he's black, we're going to hit it off and just be the best. No. But that's one mistake that people make. The other mistake is to swing the pendulum so far the other way and say race has nothing to do with anything. We had a case, it was a fire case, wrongful death, and we were having a fire inspection. And this is how these cases normally get started, it's with the inspection. So my partner comes to me and says, Kevin, I want you to go down there and represent the company and do that investigation for a couple of reasons. One, the plaintiff, or I should say the plaintiff's representative, was African American. Two, plaintiff's attorney was African American. Three, the county in which the case would be tried was predominantly African American. And so I went down there and got along fabulously with the attorney. We had a great discussion about a whole host of things. We talked about the minority attorneys we knew, both in the state he's from, the state I was from. We talked about his time in the legislature. He had been one of the first African American legislators in that particular state. A great conversation. A conversation that a white attorney could have had, perhaps, but it would have been harder to do. What happened with all of that? Well, at the end of the day, after the inspection, a few months thereafter, the case was dropped. Now, am I saying it was dropped because I had a conversation with a black attorney and we got along and had a report? No. But I'm putting the odds in my favor. And certainly it helped to send the message that we're willing to try this case. And if we do try this case, we're aware of the racial dynamics and we're going to use those to our favor. So again, putting the odds in your favor. A diverse legal team has the potential to effectively connect with a broader array of witnesses. There are so many things that you can do. Let me give you another example. There was a case we had. It was a product liability case, and we needed to get some statements from some police officers who were African American. I went down, conducted the interviews. Now, I just want to tell you about the environment. No exaggeration. It was like the discussions I had ad nauseum back in college with my boys. We just had a great time. We were talking about all kinds of things, some of which case-related, some of which not. What did that do? Opened them up, gave them a sense of comfort, got a lot of information. Now, am I saying that a white attorney could have gone down there and got the same information? No, I don't know. I can't prove that. But I certainly can tell you that I was putting the odds in my favor by going down, building that report, getting some good information that we can then come back and use in our defense of the case. You need to have a diverse legal team. You have the potential to connect on so many different levels. I'll give you another example. One, we had a case where it was down in Hale County, and we had an African-American mother who lost her son in a tragic accident. And my partner, a white male, a member of the American College of Trial Lawyers, he said, look, Kevin, I want you to take this witness. We debated whether we were going to take her at all because it's very emotional, but there were certain facts that we had to elicit for the record. But I took her on, and it worked. And would it have worked with a white attorney? Maybe, but maybe not. The optics were a little better because I treated her with kid gloves. It was another African-American, and we had a rapport. So am I saying again that this is always going to be some kind of magic hocus pocus? No, but I'm saying for you to ignore that as a client, for you to ignore that as a lawyer, to me, is not effectively serving our clients in the defense of litigation. In certain cases, a minority attorney will bring unique advantages to counsel's table as the face of the company. Certainly cases involving racial discrimination, and I will say this for a disclaimer, you'll notice most of what I've said deals with race and specifically African Americans. There carryover to other ethnicities, there's carryover to gender, but I deal with what I know the best and then let you make the extrapolations and the lessons to be taken away. But there are many cases where it helps to have a minority as the face of the company, but let me issue two very strong caveats that I learned the hard way. One, when you ask an attorney like myself to get involved as a minority attorney trying to take advantage of racial dynamics, make sure we're involved in the case, the trial of the case from day one. Here's what happened in the case we had. I was the most junior member of that case. I had minimal role, just a few witnesses. But when we struck the jury, 7 of the 8 jurors were African American. So about midway through the trial, the client comes to me and says, Kevin, we want you to do closing. Well, I'm happy to do that. That's a great opportunity for me. But I hadn't earned the trust of the jury. They hadn't seen enough of me. They hadn't heard enough from me. So I did the closing argument, and we did receive a defense verdict. But I want you to listen to what they said, because we were, with the judge's permission, able to conduct some post-verdict interviews. The African-American foreperson said something to this effect. When they put Kevin up there at the last minute to do the closing argument, we all wondered whether they did that just to pander to us, because they saw that most of us were African American. And if they thought that was going to help them, it did not. So friends, that was a wake-up call. We barely escaped a major snafu. And we put some, you don't want a jury back there talking about that kind of thing. You want the jury talking about your case. And so make sure that there is thorough involvement. I'll tell you, that lesson has been so seared in my head. Every time this comes up, I remember that and I make that recommendation. The second thing is, and we learned this the hard way, be careful, if you've got a racially mixed case, be careful about the assignments to the lawyers. We had a case, we tried, Lee and I, in Hale County, to a hung jury, which was a major accomplishment because this place was horrible. In fact, the judge was surprised that they even deliberated for several days. But anyway, when we talked with the jury foreperson afterwards, he said something that stung me because I thought, well, I'm Mr. Diversity, I've thought this all through, and I've got this. He said, Mr. Clark, I didn't like the fact that you were taking all the black witnesses. I didn't like that. I didn't appreciate that one bit. And I thought to myself, well, I know I took some black witnesses, but I had some white witnesses as well. But it's just like in customer service. The customer's always right. The jurors are right. You have to be cognizant of that. In his mind, there was an issue. It seemed like we were playing the race card too overtly for his taste. And so, in the cases going forward, I'm very careful about the right mix. A diverse legal team has the greater ability to eliminate distractions at trial. Here's what I tell my clients. I don't say, and I remember having a discussion with the clients, I don't say, now, we're in a predominantly African-American jurisdiction in this place, Bessemer, and I'm going to go in there, and I'm a black attorney, and they're going to give me a defense verdict because I'm a black attorney. No. But what I do say is this. If you've got a case where there may be African-Americans in terms of the plaintiffs or the jury or maybe the judge, let's put me or somebody like me to represent the company to take that issue off the table or to at least mitigate it. In other words, we don't want to be distracted by that. If there is an us versus them mentality out there, whether we like it or not, if it's out there, we don't want to bring that in play. Let's put some diversity on our side of the V. And so that's what we're saying. Take the diversity issue off the table from the standpoint of it being a liability and let the jury focus on what it's supposed to focus on, which is our story. But remember that diversity is a double-edged sword. This is my story I said I was going to swing back to. Remember I said we got this case because it was predominantly minority jurisdiction and the client wanted me to try it? Well, come to find out, our intel wasn't exactly right. And the first clue of that was the local counsel kept pushing back a little bit on the idea of me being the face of the company. And eventually what came out was that, in his opinion, there was a lot of prejudice in that area. And after a long, soul-searching discussion, we decided that I was not going to be the lead for the attorney. In fact, we had a bifurcation of the trial, liability and then damages. And what was decided, and I was a part of this decision, was that I would not speak in the liability phase. But if we got tagged with liability, then I would come forward in the damages phase. Now, you may say, that's distasteful, that's the heckler's veto. That's the other side of what we've been talking about. What I've always said is, I'm going to advance the cause of racial justice on my own time, not my client's dime. Now, if you as a client say, Kevin, I hear that, that's fine, but torpedoes ahead, I want to do it anyway, I'll try it for you. But I think that I owe it to you to say, I may not be the best person, and I feel a little better in some better company when I was moderating a discussion on this, and there was a federal judge who was a civil rights icon from Alabama. And I posed the same question to him, and he said, now, Kevin, as much as I hate to admit it, there are some jurisdictions where people who look like us don't need to be the face of the company. And that could apply to different ethnic groups, and that could apply to women. It's just a fact. It's a reality. I hate giving credence to the heckler's veto, but again, we're trying to win cases, and so keep that in mind. It's a double-edged sword. The last thing, do not ghettoize minority attorneys, and yes, that is a word. What I'm saying by that is this. I've talked with a lot of African Americans, and we all differ to the extent to which we will play along with this, if you will. There's some African Americans that don't want this issue to come up on the table whatsoever, don't want it to be mentioned, don't want you to think about, talk about, don't ever put them on a case that has anything to do with race. But I would say the vast majority of trial lawyers that I've come into contact with do not feel that way. They understand the dynamics, they understand the advantage, but here's what they say. Don't just put me on cases in black jurisdictions. Don't just put me on the cases with the black judges. Let me have the full panoply of cases out there. Don't ghettoize me. As long as you don't do that, I don't have a problem. You know, if you want to use my race, that's fine. I had a good friend of mine who gave a talk where she said, use your assets. Whatever your assets are, whether it be gender, whether it be race, ethnicity, use those assets in the service of your client. I'm going to leave you with a slide that's got some resources that if you want to do some more reading, not only on diversity in the courtroom, but also diversity in the larger legal practice and in corporate America. Great resources there. I encourage you to look at those. But I want to end with this point because there'll be some people that may come away with the wrong idea. Here's what I didn't say. My message is not every time you have a case in a black jurisdiction or predominantly black jurisdiction, you need to have a black lawyer. My message is not when you have a Latino plaintiff's counsel, you need a Latino defense attorney to engage in those settlement discussions. My message is not that white male attorneys cannot try a case effectively in front of predominantly African American or predominantly Latino juries. That's not my message. My message is this. We need to have intelligent adult conversations about this issue and how it impacts the defense of our clients. And we need to have a diverse array of voices having that discussion. And we need to do that at the inception of the case. And think about it, folks. If we're up here worrying about whether I use my cell phone or not in front of the jury, what kind of car am I driving to the courthouse, what kind of shirt am I wearing, what kind of tie am I wearing, how's my hair, do I wear makeup, do I not wear makeup, and then we're going to ignore one of the most salient issues in American life, race. That does not make sense to me. I think we must talk about this. And I don't know how you come out, and I don't have a cookie-cutter test, but the discussion must be had. Diversity in the courtroom, putting odds in your favor. Thank you.